Hi comrades, yours Kayveeyes. In the recent days, many divisional superintendents are issuing notices and also charges to our officials for participating in the Dharna program, demonstration and shouting of slogans likewise. What is the provision? Whether is it prohibitory? As per the Government of India decision, whatever be the judgment given by the Supreme Court or the higher courts, if it is not challenged, that will also become the order for the government employees. So, as per the court judgments, the peaceful assembly without any speech or slogan in the office premises is not a misconduct. This is as per ATC 265 of Madras High Court judgment delivered during 1994. So the peaceful assembly without any speech or slogans in office premises. Actually, while sitting in the offices, if you are having a peaceful assembly without any speech or slogan, no action could be taken against you. Then now coming to the next question. If you are having the demonstration with the slogan shouting, whether the peaceful demonstration is a misconduct? No. It is also cannot be construed as a misconduct. The rights to demonstrate to improve prospects in service is a right to visible manifestation of feelings or sentiments of an individual or group, and this communication by one idea to others to whom it is intended. It is not a misconduct. This is a very famous judgment delivered by the Kerala High Court in Balakrishnan Nair case during 1980 in KLT 264. And similarly, nowadays, the department and others are issuing instructions. If you are participating in the demonstration, it will also be considered as if participation of the strike. What is the provision? Actually, in the Supreme Court, during 1963, in the case of OK Ghosh versus EX Joseph in SC number 812, has delivered the verdict that where a government servant participates in various demonstrations organized in support of strike which was declared illegal, it does not mean that he participated in the strike. So the participation of demonstration either prior to strike or after the strike or in between the strike and whatever it may be, participation of demonstration that cannot be construed as he participated in the strike. So, and also there is another judgment by the Supreme Court in SC 311 during the year 1987 issued, a dignified protest cannot be condemned. The protest which is conducted in a dignified manner, that cannot be stated as a misconduct. The protest silent march was held by the employees during the break hours, that is lunch hours, when there was no classes or 2 days, despite warning by the principal. But there was no speeches, no chanting or shouting of slogans, no violence or disruption of studies. The Supreme Court held it is a dignified protest which should evoke sympathy. The court observed the behavior of the teachers appears to have been orderly and exemplary. One would have thought that the teachers were by their silent and dignified protest setting an example and the soundest precedents to follow to all agitators everywhere. It was wrong to pass orders of suspension of the employees. This is a Supreme Court judgment issued during 1987 in the case of Frank Anthony versus Union of India. Very excellent judgment. Actually, the peaceful demonstration without any speech, dignified protest, this has been supported by the Supreme Court. This is a very important judgment. You can also mention when you are facing such a situation. And another one, wearing the broad pledges, whether it will also be lead to misconduct, because nowadays we are issuing so many programs of agitations, wearing the badges, black pages and everything. Will it also construed as a misconduct? No. Actually, wearing of black pages would not prevent any transaction of any government services. A perfectly peaceful demonstration by wearing black pages would not in any way prevent or is calculated to prevent the transaction of the normal businesses of the banking company. This was issued in a case of bank employees, that is M. Ramu versus Government of India, 1970, that is in Supreme Court 331. So, these are all the judgments. They are in favor of conducting peaceful demonstrations, and peaceful demonstration cannot be brought under the FR 17 or anything, as if the government is nowadays issuing the circulars one after another during the time of peaceful demonstration. So keep all those Supreme Court judgments and High Court judgments in your mind, and when such situation arises, you mention all these Supreme Court judgment and everything, and thereafter definitely you will get a relief. Why? Because wherever the Supreme Court judgment or High Court judgments which was not challenged by the Government of India, that itself is also a government order. It cannot be violated. Any Supreme Court order that cannot be violated if it is not revised by the subsequent judgment. So these are all the judgments which are all still in existence. Based on these, you can prepare your draft. With this, I am concluding. Thank you very much, comrade. Meet again.